Hello and welcome. This month we celebrated the 60th anniversary of the Voting Rights Act, a law that transformed American democracy by opening the door to equal protection and representation for Black Americans and other communities of color. But over the past decade, the law has been severely weakened by ongoing attacks and damaging Supreme Court decisions. Now the court may consider another case that could strip away the law's remaining protections. At this Brennan Center for Justice live event, we'll take a closer look at the history of the Voting Rights Act, the legal battles it has faced, and what lies ahead for safeguarding access to the ballot. I'm Natalie Tennant, Kanawha County Commissioner and former West Virginia Secretary of State. I'll be your moderator for the day, and we have an excellent panel here to discuss the history of the Voting Rights Act, ongoing attacks on the law, and the prospects of revitalizing it. Please join me in welcoming U.S. Representative Nikema Williams of Georgia's Fighting Fifth, the same district as the late Congressman John Lewis. Welcome, Congresswoman. Alex Kazar, the Matthew W. Sterling Jr. Professor of History and Social Policy at Harvard Kennedy School. Lenny Powell, staff attorney at the Native American Rights Fund, and Sean Morales Doyle, director of the Brennan Center's Voting Rights and Elections Program. Good afternoon, and thanks for joining us, guests. And audience, please join us as well by adding your questions in the chat, and then we'll include them as we go along in this conversation. And Professor Kazar, it's good to be with you again on a panel. And yeah, good to see you. And I guess, as the professor of history here, we ask you to really set the scene for us and really just go to behind the scenes too. And why was the Voting Rights Act necessary in the first place?
An excellent question, Natalie, and it's good to see you again also. The simple short answer to that question is the Voting Rights Act was necessary because African Americans in the South were by and large not permitted to vote, and because Washington had concluded, or most people around the country had concluded, that Southern states by themselves were not going to remedy the situation. But that two-sentence version doesn't really do justice and help us to understand what happened. The place I would start is by looking at the subtitle of the Voting Rights Act, which almost no one ever looks at. It's called the Voting Rights Act, but it has a subtitle, which is an act to enforce the 15th Amendment. The 15th Amendment is the amendment that says you cannot deny the vote to someone because of race, color, or previous condition of servitude. Well, the interesting thing is that the 15th Amendment was passed in 1869 and ratified in 1870. The Voting Rights Act comes nearly a century later. Why? Well, the story is not all that simple. The voting rights of African Americans were enforced while Union troops remained in the South, but when they were withdrawn, then Southern whites began campaigns, often violent and certainly widespread, to prevent African Americans from voting. They were completely sort of violating and ignoring the purposes of the 15th Amendment. In an interesting moment in 1890, Congress strongly considered doing something about that, and there was a piece of legislation called the Federal Elections Bill of 1890, also known as the Lodge Force Bill. It looked a lot like the Voting Rights Act, and this was in 1890. And it was narrowly defeated in the Senate by a filibuster. But that act would have sent U.S. Marshals and federal officials into the South to enforce the 15th Amendment. It didn't happen. And then for the next 60 or 70 years, Washington paid very little attention. The federal government paid very little attention to voting rights in the South. Voting rights were suppressed. This begins to change after World War II, among other reasons. A large number of African American veterans of the war came back from the war with taking the understandable stance that if we fought in the war, we should be allowed to vote, which was hard to argue with. But Washington was still very reluctant, and the states were recalcitrant. So things dragged on in the 1950s. There were some Civil Rights Act passed, but they were pretty tepid. The temperature is building in the South in the 1960s. And then the precipitating event, which is very well known, was the march in Selma, Alabama, um, in which state troopers beat up a whole lot of people who were engaged in a march for Voting Rights Act, and that galvanized Washington. A technological point here, which is not trivial, is that it was televised. The beating of the marchers in Selma was that very evening aired on national television, producing a national outcry. And then Lyndon Johnson, not many weeks later, went to Congress, and what I think was the best speech of his career, and in effect said that we had to pass the Voting Rights Act. So again, the story is that the South was resisting. Despite the hopes of Northern liberals, there was no sign that African Americans would be enfranchised in the South if Southern states were left to themselves. And for moral and political reasons, the Voting Rights Act was put forward and passed. I want to mention one additional political reason because it's not unrelated to our contemporary world, which is the Cold War. We were in a competition with third world countries with the Soviet Union. And the Soviet Union was making very substantial, successful propaganda by pointing out that America's racial minorities were denied the right to vote. And thus, how could the United States claim to be the beacon of democracy in this global competition for allegiance?
Very, very important explanation, um, Professor. And, and it continues. And Congresswoman Williams, you see this, and we know that the VRA was a incredibly significant piece of legislation, and you see the continued fight that it takes and work, and even in modern days, as the professor said, when we talk about the Freedom to Vote Act, For the People Act, how difficult it is. And so, as a sitting member of Congress, you can tell tell us how hard it is to get legislation of this importance enacted, and just how historic this effort is.
Absolutely. And thank you so much, Natalie, for moderating this very important conversation. I was sitting here going down, taking my history lesson from the professor. So thank you for the Brennan Center for bringing us together, because y'all, we are going through it right now. And when you talk about significant legislation, the Voting Rights Act is at the top of that list, because people, no matter what issue it is that is your most important issue, free and fair access to the ballot, it sets a level playing field for you to be engaged and to advocate for the issues that you care about. And when you think about, some people might say, it's just one bill. Why can't you just get it passed, push it through, and get it done? And we heard the history lesson leading up to the Voting Rights Act. And we see everything that is happening right now, especially when it comes to access to the ballot, where it depends on your zip code, it depends on your bank account, it depends on who you are, what your access to the ballot should be, and that should not be the case. But when you look at significant pieces of legislation like the Voting Rights Act, it took years and years of work on the outside from the advocacy realm. So a lot of people will come to their elected officials and their members of Congress, and they want us to hold the magic wand and get it done. But at the end of the day, math is still math. And we still don't have the votes that we need, especially in the chamber that I serve in right now in the House. But things change. And as things change, we have to have the outside pressure, just like we saw in the lead up to the Voting Rights Act. It was individual citizens, the American public, who saw what was happening because it was televised, and they got involved and they pushed the elected leaders in this country to make the changes that we needed. So when you're thinking about legislation that changes lives in a wholesale way, like the Voting Rights Act, and changes the trajectory of history, it absolutely takes time. And these historic efforts are not just done with the leaders, it takes the people. So while I am committed to fighting for voting rights in Congress, we also know that we have to have smart attorneys like some of the people on with us today to defend things in courts, but we also have to do this in the community. And so that's what it takes. It takes people rising up in their communities about what is important to them. And so that is how things get changed, because it's only so long that elected leaders, we are only elected to represent the people. And so we have an obligation to be responsive to the people. And that is whether you agree with me on an issue or not, because there are a lot of colleagues on the other side of the aisle that need to be hearing from all of us, because that's how we make change in this country. That's how we change and pass historic legislation like the Voting Rights Act, by having more people engage, raising your voices, getting involved in the process so that your government is truly representative of your thoughts and beliefs.
Yes, so true, Congresswoman, and your call to action right there is so important, and it just to show how much you move forward, you get knocked down. You move forward, you get knocked down, and we have to continue on that. And I often think, this is a Brennan Center event that we're having here, and the president of the Brennan Center, Michael Waldman, will often tell those same lawyers, those same activists that with whom he works, that think about what it took to get the Voting Rights Act passed, that we are going to see these changes. A couple of years ago, it was the Freedom to Vote Act. It still is the John Lewis Voting Rights Act also. And we have to remember that too. We have to remember our history, that it didn't happen with those numbers and one quick action, like you say, Congresswoman. So that's a great empowerment and call to action that you have. And so, Lenny, after the Voting Rights Act was signed into law, and it has been amended over the years, what impact did it have on the political participation and representation of communities that had previously been excluded from our democracy?
Thanks so much for that question. The impact of the Voting Rights Act on political participation has been just absolutely phenomenal in the decade since it was enacted. Just one example of this is Section 2 of the law, which is what we're going to be focusing on a lot throughout the rest of today's panel. By some studies' accounts, Section 2, which prohibits racial discrimination in voting, has led to roughly 1,500 lawsuits, at least since the early 1980s, largely brought by private parties, by some estimates over 90%. And those suits have been successful 2/3 of the time. So that's hundreds upon hundreds of instances of racial discrimination that have been thwarted thanks to the Voting Rights Act. Now, I'll focus a little bit on Native American ways that the Voting Rights Act has benefited Native American communities in particular, because I think that that helps show that the Voting Rights Act is a law that, although has been, was primarily motivated in the first instance by discrimination against Black voters in the South, is important in all sorts of different areas of the country, including areas of the country where Native Americans tend to live, often called Indian country. So in addition to Section 2, one thing that the Voting Rights Act does is ensure protections for language minority groups. That has been really important in Alaska, for instance, where there are a lot of Native languages spoken in very isolated Native Alaskan communities. And the Voting Rights Act ensures bilingual ballots and election materials in covered jurisdictions. It also ensures that there must be outreach and assistance for Native voters in their languages. More generally, we've seen much higher voter registration and turnout across Indian country because of the Voting Rights Act. The statistics, as you would suspect, are the same or similar for other groups that historically have been discriminated against in voting. We've seen more Native candidates elected to local and state offices. And importantly, the law continues to do a lot of critical work still today. It's easy to think of racial discrimination in voting and in other areas as a thing of the past, but the cases that we litigate here at NARF and that other organizations committed to these issues litigate show that there remains a lot of work still to be done. Just in the past decade, at NARF, we've brought suits under the Voting Rights Act challenging at-large voting systems that dilute Native votes, discriminatory redistricting plans, and voting procedures that make it harder for Native voters to participate, like prohibiting use of tribal ID. So it's really phenomenally important law.
Yeah, and we will, as you said, we will talk about that a little bit more, specifically Section 2 and some work that you are working on. But I want to go back, as we're setting this history, and Sean, we're going to get to you, but I wanted to go back to the professor because in 2013, the Supreme Court's Shelby County decision, Shelby versus Holder, essentially put an end to a key part of the Voting Rights Act, the pre-clearance, which is Section 5 of the VRA. And so, Professor Kaczor, again, for those not familiar, what exactly is pre-clearance and why did the court decide to effectively end it?
The pre-clearance provision was inserted into the Voting Rights Act by some people who had actually studied the previous history of racial discrimination. I mean, if you go back to the late 19th and early 20th century, one might have thought that the passage of a constitutional amendment saying you can't discriminate would have been the end of it, but it wasn't, because people found a way to circumvent the 15th Amendment by having bans that were not explicitly racial, but whose consequences were racial. Well, when the Voting Rights Act was passed, key people who were involved in drafting it made I was going to say suspicious, but I think it was a shrewd judgment that enfranchising African Americans would be an absolutely good thing, but that southern jurisdictions, states and counties might try to find ways around it. For example, by switching from district to at-large elections or making other changes to the electoral system. So the pre-clearance provision was added to the Voting Rights Act to protect the Voting Rights Act. What it did was to say that in all, quotes, covered jurisdictions, that's all areas with a history of discrimination, it's primarily the South, but not exclusively the South, that in all of those areas, any changes to electoral structures or electoral systems had to be approved by the Civil Rights Division, the Voting Rights Division of the Justice Department, or a federal court in D.C. It was a way of saying you can't just make some maneuver to circumvent the intent of the heart of the Voting Rights Act, and they were absolutely right to insert this provision, because as soon as the Voting Rights Act was passed, and one immediate impact was that millions of African Americans in the South were able to vote. And one of the responses in many places in the South was to try to change the voting systems, change the boundaries of districts, monkey around with it in order to make the votes of African Americans inconsequential. But now they had to get that pre-cleared and approved, and those maneuvers were denied by the federal courts and by the Justice Department, and that served as a protection. Had the impact of deterring some other southern states and counties from trying the same maneuvers once they had seen it rejected by Washington. So the Pre-Clearance Act was absolutely central to the operation of the Voting Rights Act until, as you mentioned, the pre-clearance provision was jettisoned by the Supreme Court.
Yeah, and some folks would think, oh, well, it didn't really have an impact. It really wasn't that big of a deal. But I mean, Sean, I've heard you talk about it. When Shelby versus Holder came down, it was almost like immediate that we saw some of the impact. So what were the consequences, and how did it affect the other access in the years that followed the Shelby case? Won't you turn on your mic, Sean?
I swear I hit the mute button. Apologies.
It's all right.
As you said, the consequences were immediate and they have been quite severe. Really, within hours of the decision by the Supreme Court in Shelby County versus Holder, states started putting into effect policies that had been previously blocked by the preclearance process. So literally within 24 hours, the state of Texas announced that they were going to put into effect a restrictive voter ID law that had been blocked by the preclearance process. And many other jurisdictions followed. Without the sort of prophylactic protections of preclearance, what we were all left with were the other parts of the Voting Rights Act, including Section 2, which Lenny mentioned earlier, which allows voters and the Department of Justice to go to court to try to stop racially discriminatory practices by filing a lawsuit and challenging them. And so rather than all of these practices that would have been blocked before ever going into effect under preclearance, now these policies would go into effect, and it became incumbent on all of us who work on these issues to identify the laws, the practices, the policies that were changing and that were going into effect that might have discriminatory consequences, and go to court to challenge them and prove that they were discriminatory and then get them stopped. And so one of the consequences was a lot more work that had to be done by voting rights advocates, first to even find these policies and make sure that we're noticing when polling places are being closed or changes are being made to voting laws, and then to do the very difficult work and expensive work of going to court to challenge them. There have been many successful suits since the Shelby County decision, but it is by no means as effective as the preclearance system that existed prior to Shelby County versus Holder. So to give some examples, we at the Brennan Center, along with a number of other groups, went to court immediately after Texas announced that it was going to put that voter ID law into place. And we sued and eventually got it blocked by courts, but it took years and years and millions of dollars of resources, both among voting rights advocates, but also by the state of Texas, to litigate that case before the law was finally replaced with something that was less restrictive and less discriminatory. And that's just one of many new restrictive voting policies and practices and laws that were put into place since the Shelby County decision. At the Brennan Center, my team for now almost 15 years has been tracking every single piece of voting rights legislation in every state legislature across the country. And we have chronicled this, what's happened since Shelby County versus Holder. And in the first decade, a little over a decade since the Shelby County decision, states passed more than 100 restrictive voting laws. And every one of those laws has potentially discriminatory effects, has restrictive effects. We sometimes can prove them and sometimes can go to court to stop them. We're currently suing Texas over a big omnibus law called SB1 that the Texas legislature passed in 2021, but they passed that in 2021. We're 4 years in now fighting that battle. We've won repeatedly, but our victories are on appeal and are being are stayed, are blocked pending that appeal. So we have election after election that happens with these new restrictive laws in place. And as I said, we can sometimes prove the discriminatory effects, as we attempted to do and do in lawsuits like that one in Texas. But it's hard to really get a full picture of the effects of the Shelby County decision. And we have done some research to try to get the big picture, because it's not just all of those 100 laws that are passed. It's every time a polling place is moved. That would have had to go through preclearance prior to Shelby County. It's every time voters are purged off of a list. That would have had to go through preclearance. It's every time a map is drawn. And so trying to get a big picture to zoom out and see what the effects are, we went back to the language of the Shelby County decision. What the Supreme Court said in Shelby County was, you know, the Voting Rights Act was passed a long time ago. It was 1965. And yeah, there was a lot of race discrimination back then. We're not so sure it's still so bad. And you know, back in 1965, there was a huge gap in turnout between white voters and black voters. Black voters weren't turning out because they couldn't, because they were effectively blocked from voting. But now we go back and we look at those 6 states that were, you know, originally covered by preclearance back in 1965. And it seems like there isn't so much of a problem. There's actually almost parity between white voters and black voters in their turnout. So we're not convinced that the formula Congress came up with for choosing these jurisdictions is the right one, and we're going to throw that formula out. and that's why we have no preclearance now. So basically, the Supreme Court said we've seen this gap close, and we're not convinced there's race discrimination anymore. Well, Justice Ginsburg, in her dissent in that case, said, getting rid of preclearance because you're not seeing the effects of race discrimination is like throwing out your umbrella during a rainstorm because you're not getting wet. And we did some research at the Brennan Center that I think proves that very clearly. We went and took Justice Roberts at his word and said, okay, let's look at the racial turnout gap. He cherry picked a bit and looked at the 2012 presidential election when Barack Obama was top of the ticket up for re-election and said, look, Black voters are turning out at rates almost equal to white voters. We said, okay, well, let's see what's happened since Shelby County. And what our research shows is that sadly across the country, the racial turnout gap, the gap between white voters and voters of color, has been growing since the Shelby County decision. But more specifically, in those jurisdictions that were previously covered by preclearance, that racial turnout gap is growing twice as fast as in the rest of the country. So whether we can prove it for every individual policy change and we can identify every single thing that would have gone through preclearance before, when we zoom out and look at the big picture, the effects of that decision are very clear and they are staggering, and they are blocking and knocking millions of voters of color out of our elections every time we have elections.
Yeah, I mean, such good information and research that was done in the Brennan Center, as you said, and you could find that on the Brennan Center's website or a quick Google. We may be able to put it up too. And so let me ask this question that comes from an audience member to maybe you, Sean, the professor, or the congresswoman, I guess. Could the Supreme Court reconsider preclearance now that research shows the states have passed so many new voting restrictions in the Brennan Center voting roundup since the Shelby County case? Who wants to take that one? Go ahead,
I'll start
Congresswoman.
here because this is something that keeps me up at night, y'all. I'm a Southerner, born in Georgia, raised in Alabama, have seen this, sitting in this seat that was held by the late Congressman John Lewis, who we all know put so much on the line, not just for me to be able to serve in this body, but for so many Black, brown, everyone in this country who wants free and fair access to the ballot to be able to participate in our democracy. So this is something that literally keeps me up at night, especially with everything going on. And we have legislation in Congress to review that formula, update the formula for modern times, because anyone who wants you to believe, Sean, thank you for making it clear and giving us the timeline and showing exactly how we made progress since we had preclearance in place, and then what has happened since Shelby v. Holder, because we need to look at this in a modern lens to know that just because they're not making people count jelly beans in a jar, or you might not be paying the traditional poll tax, a lot of these tactics seek the same results that they were seeking by forcing Black people to count jelly beans in a jar. So just because the tactics look different does not mean that the end results are not the same. And so we have the John Lewis Voting Rights Advancement Act, which reviews the formula that was once used for preclearance. And how do we update that for 2025 to make sure that people still have free and fair access to the ballot, and the burden is not put on the voter after the fact, but we can look at this through a modern lens. And so that is where we are in Congress right now. And I would love to turn it over to our experts to hear more from you.
Natalie, can I come in here for a second?
Sure, take it.
Yeah, no, I agree with everything the Congresswoman said, but I think we have to recognize that the issue now is political, not legal and constitutional, to the extent that I understand it. Because you could have another case that would come forward to the Supreme Court if the objection of the Supreme Court was not to the existence of a preclearance mechanism, but to the definition of the covered jurisdictions. And if you had legislation grounded in research that redefined the covered jurisdictions, I imagine there's a good chance you could make some headway with that and change it. The problem is that in today's Congress, as I understand it, that's unimaginable, that the Republican Party and conservatives in Congress would really block that. I mean, we have to remember that key actors in the original passage of the Voting Rights Act and in the renewals, as recently as in the 2006 renewal, that some of the key actors were Republican members of Congress, and they are not there anymore.
Yeah, I mean that's it was renewed every time it came up, and the last time was 2006. So
Right.
when that question from the audience member, can the Supreme Court do it? It's Congress, as both you and the Congresswoman were talking about, and ultimately the voters. That gets to Congress. So let me ask this one. So then we've gone from Section 5. And I know, Congressman, you talked a little about what's taking place in Europe, but now that the preclearance is no longer in effect, we now have another key of the Voting Rights Act, which is Section 2. And I think there was even some reference, Sean, maybe that from the Supreme Court, that Section 2 would take care of things. But Professor Kaczor, can you explain what Section 2 was meant to do and how those recent Supreme Court decisions have impacted its enforcement? Hang on. Turn your mic on too. You guys are getting soft on me out there.
Yeah, no, I'm sorry, I lapsed in my attention. What Section 2 is designed to do is a little bit unclear. Section 2 is in a sense simply a restatement of the principle that you cannot have discrimination, racial discrimination in voting, and it would apply to to any groups, including language minorities, etc. That's basically all it says. Where it became operative, or most operative, had to do with questions of districting, and of how districts are drawn, how districts are aggregated or not. And then that kicked up the question of does Section 2 prohibit discrimination only discrimination where you can see a discriminatory intent, or does it also sort of prohibit actions like districting, which might have apparently discriminatory content, or consequences? I'm sorry. And the court has, so as far as I can read it, and I'm not an attorney, although I sometimes play one at public events, but the court spent about 25 or 30 years vacillating on that, saying that, well, and also Congress revised Section 2. It should be said, I should add it, in 1982 to say that that defining sort of discrimination as in Section 2, it was to be based on what was called the totality of circumstances. You had to look not just at how many African Americans could be elected to office, but what the total circumstances were in the passage of any given districting or other piece of legislation. So it's been embattled, uneven criteria, saying, well, you can count race as important for districting, but it can't be the most important thing. And the courts have muddled through. I think that and then here I would turn it over to those who are currently litigating this. I think that what has happened in the last decade is a shift of the courts towards a narrower interpretation, a stricter interpretation of what constitutes discrimination with respect to districting and other matters. And most recently, this alludes back to what we talked about earlier, there is a move afoot to say that there is no private right of action under Section 2. That's to say that individuals or groups of people who feel that they are discriminated against cannot file suit. They cannot say we were discriminated against. We were the victims of this.
Right.
And that is where most of the lawsuits has come from. And in effect, it's saying only the Justice Department can bring those suits. And if you'll forgive a political aside, I don't think that Pam Bondi's Justice Department is particularly interested in bringing those suits.
Right, and it's kind of what Sean was saying. When you're looking out there, there may be so many instances of it that the DOJ can't always find it. That's why you need the individual opportunity to pursue that. And that's where we come up on Section 2. And the most recent challenge is from a federal appeals court. It's called the Turtle Mountain Band of Chippewa Indians versus Howe. And Lenny, this is where your organization, the Native American Rights Fund, NARF, as you call it, is representing the plaintiffs in the case. So we need you to break down what it is about and explain why it matters to the future of the Voting Rights Act.
Thank you. So we represent the Spirit Lake Tribe, the Turtle Mountain Tribe, and 3 individual Native voters who brought a suit under Section 2, alleging that in North Dakota, the state legislative map, most recently adopted by the North Dakota State Legislature, unlawfully diluted the votes of Natives on the Spirit Lake and Turtle Mountain reservations. We, along with our partners at the Campaign Legal Center, law firm Robbins Kaplan, and attorney Brian Sells, we prevailed in the district court after a 4-day bench trial, and we convinced the district court indeed there was a violation of Section 2 and that it was necessary to order a remedial map with a single legislative district that contains both the Spirit Lake and Turtle Mountain reservations. But while we were litigating, the Eighth Circuit, in a case out of Arkansas, addressed the private enforceability of Section 2, as the professor was discussing whether you and me and anyone else who's a voter can sue to enforce our own rights under Section 2, or whether we have to rely solely on the Department of Justice to bring those suits. Now, there are 3 ways you can show as an individual that you have a right to sue to enforce one of your rights. You can show that there's an express cause of action. You can show that the statute has an implicit cause of action, or you can sue under Section 1983, which was another landmark civil rights statute passed in sort of the wake of the Civil War in order to, among other things, enforce the Reconstruction Amendments. And the Eighth Circuit in the Arkansas case said there was no implicit cause of action, and also everyone agrees there's no explicit cause of action in the statute. But the Eighth Circuit left open the door whether Section 1983 allowed you to sue under a statute that, as the professor noted, is subtitled an act to enforce the 15th Amendment, one of the most important Reconstruction amendments. We had preserved the Section 1983 issue. So when we went up to the Eighth Circuit, we had some hope that we would at least prevail on that, even though Eighth Circuit law foreclosed us on the implicit cause of action. But here too, the Eighth Circuit was not willing to consider that possibility. It ruled there was no ability to enforce the statute under Section 1983 as well. So every lawyer thinks their case is important, but we believe the stakes are truly high in this one, even though I don't think there's any debate that Section 5 was even more effective than Section 2 at preventing discriminatory voting practices. Section 2 is still an extremely important tool for prohibiting discrimination in voting. And right now, everywhere else in the nation, other than the Eighth Circuit, private plaintiffs can rely on an unbroken line of Supreme Court and circuit precedent to enforce the individual rights given to them by Congress and the VRA, but not in the Eighth Circuit, where citizens now have fewer enforceable rights and protections against racial discrimination in voting than citizens everywhere else. That's especially a problem for Native voters, given the high percentage of Indian country located in the Eighth Circuit. But of course, ultimately, the Eighth Circuit's ruling forecloses all voters within the geographic boundaries of the circuit from enforcing their rights under Section 2. And of course, we're now at the Supreme Court stage, which means the case could affect everyone in the country. And on that score, the nationwide importance of Section 2 can't be understated. Every case that the Supreme Court has decided under the current version of Section 2 was brought by private plaintiffs. That includes the most recent decisions like Brnovich and Milligan, and the decisions going all the way back to when Section 2 was most recently revised in 1982, as the professor noted, like Thornburg v. Jingles. And the need for private enforcement has never been higher because, as again the professor noted, the current political situation illustrates that we cannot rely on the Department of Justice alone to enforce these rights. That's true in the best of times, and it's certainly true now when VRA enforcement at the federal level by the Department of Justice is basically non-existent.
Right.
Now, thankfully, we're optimistic about our chances. We requested and received an emergency stay from the Supreme Court, with 6 justices voting in favor of granting us relief. So we think it's
Yeah.
likely that the Supreme Court will take the case and reverse the Eighth Circuit's previous error here.
Yeah, we're certainly counting on that positive outcome of that, and it is true. We're following the advocates, activists are following your case, and I do want to point there is, and maybe we'll get the link put up. The Brennan Center kind of has a timeline of the court cases and the work that the Brennan Center has been doing in the Turtle Mountain. Chippewa Indian versus Howe, and we'll send that link and put it for the audience to see as well. Let's get to some more of the questions from the. Okay, this is a simple question for you, Congresswoman. How often does the Voting Rights Act need to be renewed, and why isn't it permanent?
So I think that is a age-old question that we've been hearing a lot, because we often go back to the framework of it was renewed this many times under Republican administration, and now we can't get bipartisan support for this. But I think it's also important to know, when we're looking at the timeline, and we talked about how long it takes to get big pieces of legislation passed, and what this looks like is that we actually got an updated version of the Voting Rights Act. When we look at pre-clearance and that formula, we passed it through the House last Congress with the democratically controlled House, and made it over to the Senate, and we couldn't get it out of the Senate. So I think it's important to look at this in the context of so many other things. When we were initially trying to get voting rights legislation passed, and some of the concessions that were made around pre-clearance and the renewal, we were trying to gain rights. Right now, people already have this right, and we're trying to protect it. So it looks a little different. And so when we look at this current state that we're in this country, when we have legislators in Texas that have literally had to run away from home just so that they can stop the government from choosing letting elected officials choose who they represent instead of the people choosing their representatives. We have people leaving the state because they might say, when you talk about Republicans and our leaders, they're going to say that this isn't racial gerrymandering. You're going to hear a lot about the word gerrymandering in the upcoming weeks. But when you look at a lot of states, especially like the one that I represent in Georgia, in my district, sometimes you cannot separate the partisanship from the race because of the historical context of what has happened in the South. And so we have Democrats are literally voting on one side of the aisle and Republicans voting on the other side. And so it becomes that race is aligned with partisanship often in the South. And so my district in Atlanta, Georgia, I represented 3 different seats in my first 3 years of Congress. I've only been in Congress 5 years, and I've had 3 different districts, and my lines are back in court because we are pushing back against racial gerrymandering. And sometimes it's under the guise of partisan gerrymandering, which is what you're hearing in Texas and some of these other states. So, and now we're moving forward with still pushing the John Lewis Voting Rights Advancement Act so that we can strengthen the VRA. But just on the 60th anniversary of the Voting Rights Act, I introduced 10 individual pieces of legislation, my voting rights package, which is even more comprehensive and takes us further than where the Voting Rights Act was. And I think it's important that we have the groundwork, but we should be aspirational when it comes to voting rights. We should make sure that everyone, regardless of their zip code or where they live in this country, has access to the ballot. And that's what this legislative package that will make sure that voting is accessible to everyone, helping end long lines, easing language barriers while voting, and making sure people don't have to decide between going to work or voting, is comprehensive. That takes us a little further, because in this day and time, what we know is that we have to be bold and unafraid when it comes to voting rights, just as our opposition is when it comes to restricting the vote. This is our civil rights moment, y'all. And it's time for us to step up and lead in this moment as if our rights depend on it, because they honestly do right now.
That's right. That's right. And so, it answers a question that one of our audience members had, what are the odds of reintroducing the John Lewis Voting Rights Act? Well, all of those 10 pieces of legislation that you introduced, they can get introduced but what's the possibility of having them passed any time in the future? Like, are we going to see
I
it in
mean,
this Congress? And it
we
doesn't
have
have
to
to be
be
you
real.
talking. It'd be Sean, it'd be the professor and Lenny. Go ahead.
We have to be real with people. The math is the math. And right now, as the professor told us earlier, he wishes, and so do I, that there is this groundswell of bipartisanship around making sure, because this should not be about one party or another or one person or another. This is about everybody having fair access. But right now, the math is the math. And I have not seen Republican colleagues lining up to say that they want an equal and level playing field. As a matter of fact, they're doing the opposite right now. And they're lining up with our president, who's calling governors and putting pressure on local elected officials to either find 11,000 votes in Georgia to change the trajectory of a presidential election, or to find 5 congressional seats in Texas to change the outcome. So right now, the math is the math. But we have to understand, as I told you, I sit in this very historic seat, and Congressman Lewis told us, don't get lost in a sea of despair, because our fight and our struggle is not the struggle of a week, a day, or a month. It's the struggle of a lifetime. He's fought this battle. He's teed it up, and I'm here to run my leg of the race. But I need so many people, like the experts on this call, the people that are joining, watching the Brennan Center Live, and just the expertise from the Brennan Center, because we're all in this together, y'all.
Does that inspire you, Sean? Are you ready to go? I mean, because
Absolutely.
I see the work that Sean does, and I hear what the professor says, and he works well with us as part of the historian program that we have, and I mean, even though the math is not there, Sean, as the Congresswoman says, there still has to be preparation and the foundation still built to be ready.
Absolutely. I think, as we've heard over and over again today, the fight to get the Voting Rights Act didn't happen overnight. The fight for any legislation of this significance is not going to be quick or easy. And that's why we've been working on pushing for legislation like the John Lewis Voting Rights Advancement Act for years. We came achingly close, as Representative Williams already said, in the last Congress. We didn't quite get there because of the filibuster, but I believe that we will get there in the future. Unfortunately, we have to constantly stay on top of what the Supreme Court is doing as it continues to strike blow after blow to the legal protections that we have for voting rights, to make sure that when we do have that opportunity to get something done in Congress, that we are taking account of everything that the courts have done and the current state of affairs. But it's about building the groundswell of support that's going to be necessary. Sadly, in 1965, it took not representative at the time, but John Lewis and many other brave people putting their lives on the line and being brutally beaten on Bloody Sunday in front of television cameras for people to finally realize that we needed to get something done. I pray that is not the kind of thing that is necessary at this time to build that groundswell, but we need that groundswell of support. People in Washington need to see that they have no other option but to pass this kind of legislation if they want to do what their constituents want from them. And so, I've seen some of the questions folks are asking are about what the public can do. The public needs to make sure that their representatives hear them. That always, first and foremost, means going and voting in every election. And it also means reaching out to your representatives and telling them that having a democracy that functions, that is representative, that is responsive to the needs and the will of voters is on the top of your list of political priorities, and that you want them to take action to make sure that kind of thing happens. They actually do care what their voters want, and they're listening to you. So you need to engage in that way. And in all of the other ways that you can engage in our democracy, the reality is that democracies, if we want a better democracy, if we want to build to the democracy that we all deserve, it requires everybody to invest in our democracy. This is not the time to throw up your hands and say it doesn't work and I'm not going to pay attention. This is the time more than ever to go out and participate And whatever that means, it means talking to your representatives. It means participating in peaceful protests. It means writing letters. It means getting your fellow citizens engaged and registered and voting. It means signing up to be a poll worker. It could be any of these things, but people need to invest in our democracy if they want to see it function, and more importantly, if they want to see it improve and become the democracy that we truly deserve.
Yeah, great ideas, because I do see suggestions, questions coming from the audience about what they can do, suggestions on what they can do. And also, you know, I mean, you say, Sean, talk to your congressional representatives, and you may be looking, you may be in a state, example, West Virginia right now, where I am, and you know, I always have to apologize for the non-vote or the no vote, I guess, that Senator Manchin had. I just heard someone talking about him on TV recently, and it's like, oh, I know we were so close. But even if you are in those states, still, you know, and you think you know how your representative, your federal representatives are going to vote, you still need to tell them. You still need to put them on record and hold them accountable. Certainly there are a lot of folks doing it here in West Virginia. And so one suggestion, Professor, we go back to someone says, do we need a constitutional amendment to protect voting rights, and what would that look like?
I think it would be a great idea to have a constitutional amendment to protect voting rights. And in fact, 20 odd years ago, my friend Jamie Raskin and I drafted one, and it was being promoted in Congress by Jesse Jackson Jr. And we even had 50 co-sponsors, I think. So I think it would be an excellent idea to have a constitutional amendment to protect voting rights. I think it might change the nature of some legal cases, and you know, I think back to the decision in Bush v. Gore, if anyone can remember that, back to the disputed presidential election of 2000. And the comment of Justice Scalia in the oral argument saying that, with respect to presidential elections, saying there is no right to vote for president under Article 2, Section 1. And he's absolutely right. So I do think we need to, and we want to, enhance those constitutional protections. That said, although maybe I'll save this to my closing arguments, I think we also have to recognize that we inhabit a very different political world than the world of the 1960s. And you know, and a world where, you know, I mean, I can think fondly of the Republicans in the 1960s, or of Sensenbrenner in 2006, who had different attitudes, but that party structure is gone. And a final comment here, and then maybe I'll get to say something else in conclusion. We have to recognize that one of the reasons that the party structure and party composition in the United States changed, turning a Democratic South into a Republican South, and changing the voting location of African Americans. It changed because of the Voting Rights Act and the Civil Rights Act, which not only drew African Americans to the Democratic Party, but led whites to leave the Democratic Party in large numbers and become conservative Republicans.
Okay. Let me ask. We're nearing our end, and I'll have a couple more questions for folks. But you know, an audience member snuck in a question that's not exactly for the voting rights, but it is very important. It's what's happening day to day, and we're hearing various things of the attack on our democracy. It could be hour by hour, day by day, but one of them is: are there any protections against President Trump's new promise to ban mail-in voting? Who wants to take that one?
I'm happy to, unless Lenny wants to. The answer is absolutely. What President Trump said yesterday in his Truth Social post about issuing a new executive order to ban mail voting or to get rid of voting machines, I want to say he emphatically does not have the power to do. The Constitution does not give the president any power to regulate our elections. He's already tried to engage in this kind of power grab with his first executive order, and that's why the Brennan Center and other organizations went to court to stop him the first time, and we have an injunction against his first executive order while we continue to litigate that case. And I am confident that if he were to issue the type of executive order he talked about yesterday, it would also be blocked by the courts. He doesn't have this power, and just because he says he's going to do something doesn't mean he can. We've seen him say he's going to do a lot of things and try to do a lot of things, and some of them are blatantly illegal. For instance, the birthright citizenship order. That's why it was blocked right away. And the same thing would happen if he were to issue an order like the one he talked about yesterday. That doesn't mean it's not important, and doesn't mean we shouldn't be paying attention to what he said, because what he said was he was explicit about what his goal is, and his goal is a federal takeover of elections. He believes that he should have the power, as he said, to control the states as his agents in deciding how votes are counted and tabulated. And I think we should be very worried about that type of federal takeover of our elections, and it puts a lot of the other things that he is doing into context. He told us what his goal is.
Yeah, and I would remind folks, and this is something where you can support your local election officials. I, as a county commissioner, is feeling that impact of what are we going, what type of change do we need to make, and obviously, we don't think there's much of a change that we should be making, but it is certainly putting pressure and monetary pressures. And so that's why folks who are listening and in on this and want to be able to support your local election officials, from your county clerks to your city clerks, municipalities, county commissioners. So yes, you can help support and show that strength that we don't have to follow an executive order because it's not the law. So let's as we're wrapping up things, I want folks to answer this question in a few sentences. What's the one thing that you want our audience to walk away with this afternoon? And Professor Kaczor, we're going to start with you.
I think the one thing I want people to take from this is that times change and things change and conditions change, and it's possible to accomplish things at one time that you never thought were possible before. I mean, I think we are living in a difficult, challenging, and maybe pessimistic period right now with respect to voting rights and many other rights. But I think that one of the things we have to understand is that thanks to the kind of efforts that everybody is talking about, but also thanks to changing historical circumstances, what seems impossible today might look possible 5 or 10 years from now. And I think that can lead you to have nightmare scenarios, but it can also be a source of optimism and hope.
Very good. Thank you, Congresswoman.
Professor, I'm leaning on to every bit of optimism and hope that is possible. But what I need everyone to realize is we talk a lot about the civil rights movement, especially those of us from the South. And if you ever wondered what you would have done during the civil rights movement, if you ever think, well, that was a long time ago and it has nothing to do with me, y'all, we are living in unprecedented times, and this is our civil rights movement. So if you ever wonder what you would have done, if you would have been around in the days of Congressman John Lewis and fighting to achieve the Voting Rights Act, this is your time to absolutely find out. It is time to step up. It is time to use your voice to find a way to get in the way, because y'all, this is our civil rights movement.
Lenny, go ahead.
I think the thing that I would stress is that racial discrimination, including racial discrimination in voting, persists, and that the Voting Rights Act remains an essential tool to combating that. I imagine that this is an audience that doesn't need too much convincing on that score, but there are a lot of people in this country who I think are much less certain about the degree to which racial discrimination continues to exist in our country. And I think that we all need to do what we can to elevate those stories that really show the ways that the Voting Rights Act still remains essential.
Very good. Sean?
I agree with everything everyone said. I want to say, I'm very grateful for the other folks who are on this panel, for the work of organizations like the Native American Rights Fund, for the work of folks like Representative Williams to actually try to get change done in Congress, for the work of, Professor Kaczor and historians who are here to remind us the way that change happens and to give us the kind of hope that he just did. I'm so grateful for all of you. So thankful that you joined us today. And I will close by saying that I hope you all hear that all of us are saying it will be incumbent on all of the voters and all of the people to ensure that we maintain our democracy, maintain voting rights, and more importantly, get to the democracy that we've always been fighting for and that we truly deserve, that will be responsive to the needs of everyone in this country. And so I hope you hear that message and take it to heart.
Well said. Thank you, Sean. And thank you to all the guests for being here. This has been an honor to talk with you today. And thank you to the audience for your participation also. We could continue to talk about this, but we need to get out and work now. Well, the Brennan Center looks forward to seeing you at future events. And to be the first to know about what is taking place, you can log on to our events newsletter at brennancenter.org/events. I'm Natalie Tennant, Kanawha County Commissioner, and thanks for joining us, and we'll see you next time.